Good afternoon. Glad to see everybody is enjoying conversation and lunch, but we're going to kick this off. Welcome to the JBI Human Rights Lecture. My name is Melanie Nelkin, and it is my pleasure to welcome you here today for this program on behalf of the Administrative Council of AJC's Jacob Blaustein Institute for the Advancement of Human Rights, on which I have served for many years. We are grateful for the presence of so many distinguished guests in our audience today, and many diplomats who have joined us for today's program, notwithstanding the pressures of the UN High-Level Week, and I'm sure traffic was part of that. The JBI Human Rights Lecture is made possible by a generous gift from and the wise counsel of Robert S. Rifkind, a distinguished attorney and civic leader who served as chair of the Institute's Administrative Council from 2000 to 2007, and who remains an active member of JBI's steering committee, and I hope he's listening. The aim of the Distinguished Lecture Series is to provoke thoughtful consideration and action to strengthen the efficacy of law as a means to guarantee and protect the human rights of every person, as well as to address the legal and moral challenges that complicate these efforts. Bob Rifkind has been an inspiration to JBI's Administrative Council and staff, and today's event would not be possible without his advice and support. I'm also pleased to welcome Professor Yuval Shany, Hirsch Lauterpacht Chair in Public International Law and former Dean of the Law Faculty at Hebrew University of Jerusalem, and he will address the subject of international law under fire, international rule of law, lawfare, and the Gaza war. There could not be a more timely subject for our discussion today, nor a more esteemed expert to explore it with us. I think I can speak for all the members of JBI's Administrative Council, of whom there are several here today, when I say that the unparalleled crisis of confidence that many Jews are experiencing in the legitimacy and value of international human rights law and mechanisms today as a result of how international actors and bodies have addressed the conflict in Gaza and the legality of various acts of Israel, Hamas, and is deeply alarming. We are urgently in need of a course correction, not least because when these mechanisms fail to address events in the Middle East in a credible way, they harm Israel's security and only fuel anti-Semitic attitudes around the world. But we also urgently need these international bodies to more effectively and credibly address human rights crises and atrocity crimes, including genocide, that are occurring elsewhere around the world, in places from Sudan to Ukraine to Venezuela and Iran, with devastating implications for global security and our shared values, including the universality of rights. Strengthening these mechanisms has long been a priority for JBI and is so now more than ever. I now invite Kristen Broker, JBI's Deputy Director, to introduce Professor Shany and today's lecture. Thank you.
Thank you, Melanie. And thanks also to all of our esteemed guests who've joined us today for the JBI Human Rights Lecture. The honor of introducing our speaker in the lecture series today is bittersweet, as I'm standing in for JBI's director, Felice Gare, who's not able to be here today due to illness, but whose substantial achievements in the field of human rights are known to many of you. This December, we will mark 10 years since the first JBI lecture was delivered, thanks to the generous support of Bob Rifkind, who saw, as we did at that time, that changes were occurring in international relations that were poised to subject the international legal order in which the universality of human rights has a central role to a stress test that's potentially even more taxing than any it has encountered before. Dating all the way back to the 1945 San Francisco Conference, where the UN Charter was agreed and signed, AJC, and following its founding in 1971, the Jacob Blaustein Institute embraced the concept of universal human rights as essential to global security and encouraged governments to make ever more precise commitments to voluntarily restrain their use of coercive force and use it only to the extent strictly necessary for legitimate purposes in times of peace and war. And we also encouraged the development of international mechanisms to hold them to these commitments. JBI pushed states, including the US, to ratify the Genocide Convention, the Convention Against Torture, and other treaties, and to work together with a broad group of allies at the UN to press governments to respect those and other obligations, like the principle of non-discrimination, the right to religious freedom, and so on. And those efforts led to significant achievements. Some governments have changed their practices for the better, and those that haven't have been subject to public scrutiny by UN bodies that has helped catalyze international concern about human rights crises. In the last 2 years alone, JBI has engaged UN bodies that have adopted resolutions condemning and establishing new mechanisms on the crackdown against protesters in Iran, Russia's invasion of Ukraine and its repression at home, the ongoing atrocities being committed in Sudan, including the risk and potential commission of genocide in Darfur. JBI has supported and encouraged human rights defenders from Venezuela, North Korea, and even Uyghur activists taking on the greatest challenge of all, bringing UN scrutiny to bear against China. And as recently as 2021, we had made great progress in working with several independent UN human rights experts to co-sign statements and acknowledge rising global anti-Semitism as a serious human rights challenge and pressing governments to step up their efforts to combat both it and specifically Holocaust denial, online and offline. Human rights norms and UN enforcement mechanisms have always been vulnerable to selectivity and to politicization, and they have long been a target of attempts at capture by a wide range of actors. Until recently, though, we could credibly make the case that their value added far outweighed the harm that their occasional misuse would do to our interests and values. But since Hamas's October 7th attacks on Israel, it has become increasingly difficult for us to make that case. The UN mechanisms on Iran, on Sudan, on Ukraine, on Venezuela and North Korea, on religious freedom, on the prevention of torture, on the prevention of genocide, and many others are still doing vitally important work. And they're carrying it out with integrity, impartiality, and a commitment to factual accuracy, as well as a deep desire to encourage effective change. But too often their pronouncements barely register in most media, let alone provoke effective state action. And at the same time, they are being drowned out and in some cases are facing relentless criticism and hostility and pressure from another camp. And among the members of that other camp are actors that are ideologically opposed to liberal ideals, are eager to take advantage of an opportunity to displace the dominance of the US and international bodies, or more narrowly, are specifically opposed to Israel's continued existence and are singularly focused on using international law and bodies to weaken it. Intentionally or unintentionally, a wide array of other UN actors and bodies than those I mentioned are being used as tools to advance this goal. They're being provided with an incomplete picture of the facts on the ground, in which Hamas and Hezbollah are nearly or entirely absent, leading them to make deeply flawed interpretations of Israel's intentions in carrying out its military campaign and the legal consequences of its actions. And rather than acknowledging the imperative to correct these design flaws that lead to deeply flawed outcomes, the majority of governments are sitting passively as more motivated actors propose one-sided resolutions, complaints, and initiatives, and create a feedback loop that has real-world harmful consequences for Israel and for Jews who are increasingly fearful of and being targeted with harassment and discrimination and even violence. This is not the first JBI lecture that Professor Shany has delivered. Several years ago, we asked him to speak on the subject of universality and the means by which international human rights bodies can most effectively promote that norm. We've asked him back today because he's in a particularly important position of authority from which to critique the performance of those international mechanisms, particularly, but not only those that are specifically focused on human rights today. He is among the most esteemed Israeli human rights figures internationally. Not only is he the Hirsch Lauterbach Chair in Public International Law at the Hebrew University of Jerusalem and former dean of its law faculty, he also served with distinction, like JBI's director Felice Geer, on one of the UN's human rights mechanisms in an independent, unpaid expert capacity. He served on the Human Rights Committee, the most prestigious of the 10 UN human rights treaty bodies, which are groups of experts that monitor states' compliance with specific treaties they've ratified. They're not in the news nearly so often as some other UN entities, but they're extremely important to the activists that engage with them and to the governments that have to engage with their recommendations. He was nominated for that post by the government of Israel, but then elected by other governments that have ratified the Civil and Political Rights Convention. And then, in a testament to the high regard in which his work is held, his expert colleagues elected him chair of the committee, a great honor. Since October 7th, we've been so grateful to see Professor Shany step into the fray, engaging in public debates and publishing articles and commentary aimed at persuading skeptics that the most outrageous claims against Israel are, in fact, unfounded, and that the way actors like the ICC prosecutor are approaching this situation are simply out of step with how they handle allegations of wrongdoing in other places. More broadly, he has helped sound the warning bell that these excesses, these distortions jeopardize the legitimacy of the UN's human rights system as a whole, on whose effectiveness the lives of so many people around the world, people with whom JBI works regularly, women in Afghanistan, Baha'is in Iran, dissidents in Russia, and so many others depend. We're grateful to him for agreeing to address us on this most challenging subject today. And now, without further ado, I will turn the floor over to Professor Yuval Shany to deliver the JBI Human Rights Lecture.
Thank you very much, Kristen, for this extra generous introduction. Thank you also to Melanie for introducing, for opening the event, and more broadly, thanks to JBI for asking me again to speak in this very prestigious lecture series, and also to AJC for hosting us here. And thank you all for coming and spending this lunch hour with us. So I will be talking about, I will try to deal with with a broad brush with some general trends in international law and international human rights law. And I look forward to engaging with your question at the end of my written comments. I believe there is little controversy around the proposition that the international rule-based order, which comprises both of rules, formal rules, but also informal rules that undergird the international peace and security infrastructure, is in a deep state of crisis, given the omnipresence of many high-profile violations of international law that pertain to high matters of peace and security, such as the Russian invasion of Ukraine, the eruption of violence in the Middle East, persistent concerns about China's policy vis-a-vis its neighbors, human rights issues in countries such as Venezuela and Turkey that had been experiencing backsliding. And one may add to this sense of lawlessness and maybe helplessness also the ongoing climate crisis, which the international community is struggling to effectively confront, crisis around governance of digital technology, immigration crisis, and the list goes on and on and on. And in fact, what is underlying these multiple crises is a sense that has been termed as perma crisis, which has been the 2022 Collins Dictionary Word of the Year. And that can be traced back, I would posit, to a chronic weakness of international enforcement mechanisms. These mechanisms do not have the material capacity to enforce international law, and often do not have the political will to enforce international law against nefarious actors that either reject international rules or don't consider themselves to be bound by them if they conflict with their political interests. And whereas under enforcement of international law is nothing new to those who have practiced international law, and one could say this has always been a serious problem with international law, perhaps the seriousness of the violations that we are seeing and the crises that we are confronting and the challenge that they pose to world order is the worst that we have seen in recent decades, at least since the end of the Cold War. Now, but I will claim today that the problem that we are seeing runs somewhat deeper than the challenge posed by a few rogue states or cynical actors, and that the international rule-based order is in a state of crisis also because of the way in which international law norms are being applied against states who are interested in principle in maintaining this order, or at least are not opposed to it in principle, but find themselves unable to protect their most basic legitimate interest within a particular version of the normative framework that is applied to them by various international law apply mechanism. The result being that these states as well are being pushed to adopt a more confrontational approach towards the rule-based order than they would have otherwise liked to. And this process, which I will elaborate on, is further accentuated by political bias that Kristen alluded to in the operation of some international organizations that undercut the authority of the law application exercises they undertake, but also by domestic populism in many countries that resist the grant of any authority to foreign institutions that conflicts with choices that are made by the local demos. I would stipulate that this dynamic of overclaiming is particularly apparent in international conflicts, which are often asymmetric in nature, involving rogue states or non-state actors on the one hand and states on the other hand. Examples could be the civil war in Syria, the wars against Al-Qaeda and ISIS, where I would agree with the characterization that international law has been at times applied as a method to counter the military and political dominance of US-led coalitions involved in these conflicts. A prominent example on which I will elaborate further on when discussing the situation in Gaza, but is also relevant to the wars in which the United States had been involved in the last 20 years, has been the claim that there is no right to self-defense under international law against terror groups operating from within the territory of rogue or failed states, even if the latter states are unwilling or unable to curb the activities of these groups. I will focus in my presentation on the current wars that Israel is engaged in with Hamas in Gaza and with Hezbollah in Lebanon, in order to illustrate the dynamic of erosion of the rule-based order due to choices made by actors who are purportedly supporting its very existence. So the first point which I want to make about the conflict that Israel is currently finds itself engaged in, is that both current conflicts in Lebanon and Gaza are taking place in the aftermath of failures by international community, by international bodies, by international law institutions to enforce international law in order to maintain regional order and stability. So they are in and of themselves the result of a rule failure. Israel, as you recall, has withdrawn in 2000 from South Lebanon. It also withdrew in 2005 from the Gaza Strip. In both cases, it acted largely in a manner that is compatible with its international law obligations, with the framework that international law introduces. The UN confirmed after the Israeli withdrawal from Lebanon that it did withdraw to the international border, the so-called blue line. And there has been no serious claim that the withdrawal from Gaza has not been to the international boundary between Israel and the Gaza Strip in 2005. Still, both of these border areas have become the locus of consistent border attacks against Israel, I would say in violation of international law. It's also interesting to note in this regard that in both conflicts, there has been an attempt to introduce international security arrangements in order to stabilize the situation post-Israeli withdrawal, and that those attempts have failed. So in the Gaza Strip, the EU has sent a border assistance mission into Gaza after the withdrawal by Israel in order to monitor the famous Rafah crossing, so to ensure that there are no weapon transfers or a entrance of terrorists into Gaza from that border. But that operation only lasted for 2 years between 2005 and 2007. Once Hamas took over the Gaza Strip, the monitors took refuge in Israel, and the operation has ended effectively. And in Lebanon, the famous Resolution 1701, which is very much in the news these days, did provide for an international force to UNIFIL to ensure that southern Lebanon would remain demilitarized after the 2006 war, but it has failed to do so, and Hezbollah has gradually rebuilt its military strength in the region. So the upshot that in both cases, a withdrawal to an internationally recognized borderline has resulted in a power vacuum. And against the background of the failure of both the Palestinian Authority and Lebanese government to maintain their governmental authority in these areas, and due to the feebleness of international bodies that have accepted peacekeeping or security monitoring roles, both regions became launchpads for radical militancy and hotbeds of violence and instability, culminating in attacks against Israel on October 7th from Gaza and October 8th from Lebanon. The second point which I want to make in this regard is that almost every step that Israel had taken since 2005 and 2006 to protect its national security against the growing threat posed by militant groups in Gaza and Lebanon, post its withdrawal from those areas, including acts taken in the context of the current conflict, have encountered legal demands by major international law bodies and notable experts who were highly critical of the security measures that were taken and based their legal positions on what I would characterize as a debatable interpretations of international law doctrine, whose major flaw, in my view, is that they tended to ignore almost completely Israel's serious security concerns and the regional order implications of the positions that they have espoused. Now, since international law, paraphrasing Justice Jackson's famous statement about the US Constitution is not a suicide pact, and since the security implications of compliance with those legal demands that were made by the aforementioned bodies and experts for Israel would have been most serious and based on what I regarded as what I alluded to as legally dubious legal constructions, it is not surprising that many of these demands were rejected by Israel. So the result is that the cumulative effect of raising multiple legal demands that were rejected was to gradually push a state like Israel into a perceived zone of lawlessness, which would add, I would say, to other policy areas where Israel deservedly is acting in a zone of lawlessness. So I would highlight in this regard specifically its West Bank settlement policy, where that policy in and of itself appears to contradict Israel's legal position regarding the applicability of the laws of belligerent occupation in that area. But the sense that is generated out of these more controversial demands is that international law is not reasonably applied against Israel across the board. And this is used by elements within Israel and within the Israeli government to very easily deflect international criticism, including with regard to those areas where criticism is very much deserved. So in other words, biased or unrealistic international criticism of a country like Israel does have across the board implications for the ability to enforce any part of international law vis-a-vis Israel and feeds into domestic narratives, which are highly politicized, that maintain that international law should be ignored because it is applied in a consistently biased manner. So I want to give a couple of examples of what I consider those demands that are legally debatable and are oblivious to security interests. So one prominent example of this dynamic is the policy of siege or blockade that Israel imposed on the Gaza Strip following the rise of Hamas into power in Gaza. Now, this was not considered under international law, I should say, under international humanitarian law, in a state of armed conflict, belligerents do have a right to impose naval blockades and lay sieges on one another. Of course, there are certain conditions that need to be respected. For instance, proportionality has to be maintained. But for UN experts that have reviewed this policy, this was not at all regarded or conceptualized as a legitimate act of war, but it was described as a form of collective punishment, and also as a measure which led to the continued application of the laws of belligerent occupation to Gaza, notwithstanding the fact that Israel withdrew from that area in 2005. And I will note that this has been a rather controversial interpretation, because before 2005, there has never been a serious proposition that occupation can be upheld without boots on the ground. This was seen as one of the basic requirements of occupation, unless we are talking about a specific exception of a puppet government, which is not relevant here. So these sweeping claims that were made, as opposed to other claims that could and should perhaps have been made regarding, for instance, the tightness of the blockade, the list of goods that should have been entered even in a blockade into Gaza, appear to feature the criteria which appear to feature the criteria that I have alluded to, in the sense that they are based on a controversial legal proposition, and they are oblivious of Israel's clear security interest not to allow Hamas, an internationally recognized terror organization, to obtain through sea or land weapons and other materials that could facilitate and advance its aggressive designs against Israel. A second example, which I've already alluded to briefly, is the question of whether Israel even has the right to use self-defense against terror groups in Gaza and in Lebanon after 7 October. This was challenged on the basis of a ruling by the International Court of Justice from 2004 regarding the wall that Israel constructed in the West Bank. But the court has taken, in fairness, a similar position also in other conflicts, such as the Congo versus Uganda case. According to this position, a state does not have a right to self-defense against a non-state actor under the UN Charter, especially when that non-state actor is operating from occupied territory. So the idea was that the state that is confronting a sort of an attack from a non-state actor, according to this understanding of international law, which has been quite criticized by many international law scholars. According to this construction, there is no right to self-defense, notwithstanding the serious security implications of adopting this approach. In the same vein, I would note that, for instance, we have seen in recent months several UN rapporteurs referring to the targeting of Hamas leaders as unlawful assassinations, again, rejecting the possibility that this is an armed conflict governed by the laws of war, in which members taking direct part in hostilities would be lawfully targeted. Again, this is not something that is only relating to Israel. Like I said before, similar parallel arguments were also raised vis-a-vis the United States and other states involved in military operations against ISIS and Al-Qaeda. But I would maintain that these legal claims are certainly not universally accepted, and that they do not provide countries like Israel with any feasible legal solution that would address their very real security needs, their very need to defend themselves and their citizens, other than perhaps going to the Security Council in vain. The third and last example, which I would want to give in this regard, is that it has to do with the current war in Gaza, and the opinion that was issued by the ICRC mission in Gaza, that regarded instructions by the IDF to civilians in Gaza to evacuate certain areas in which fighting was expected to, high intensity fighting was expected to take place, This was characterized by the ICRC and other human rights bodies, including the High Commissioner for Human Rights, as a form of a forced displacement and collective punishment, notwithstanding the fact that under IHL, International Humanitarian Law, the body that regulates armed conflict, states involved in an armed conflict are actually under a legal obligation to warn civilians before conducting attacks. And certainly there is even if this is not legally required, it would certainly seem to be compatible with the general spirit of the Geneva Conventions to provide civilians a warning before hostilities take place in a certain location. I will skip in the interest of time. I will just know that there are serious legal issues about these evacuations, which need to be addressed, such as the conditions under which people can leave, what happens to people who are left behind. I mean, there are certainly serious issues, but again, the legal position that was put forward was not a nuanced legal position that balances between operational needs and also humanitarian needs. But rather a sweeping claim that what Israel is doing in this specific and complex battlefield situation is completely unlawful and in fact borders with international criminality. So what's striking about these different holdings, in my view, is not so much their legal plausibility. I would argue that some of them are, I would accept that some of them are legally plausible. It's that the indifference with which they deal, or rather refuse to deal, with national security concerns. And many of them, actually, many of these national security concerns were sadly validated by the events of October 7. And in a way, they also seem to be indifferent with respect to international law compliance. Because a legal position that claims justifiably, fully justifiably, for instance, that the principle of proportionality must be respected in an armed conflict, including an armed conflict with a non-state actor, with guerrillas that operate from the midst of densely populated civilian areas, but at the same time maintains that those civilians cannot be evacuated or encouraged to leave those same areas in which the guerrillas embed themselves. The result of this would be to encourage guerrillas to continue to operate from heavily populated civilian areas and present the other state with a tragic choice, either refrain from defending itself and using force in that regard, or go forward and use force and be accused of violating international law, whatever they do, whether they evacuate civilians or whether they do not evacuate civilians. Such artificially constructed situations of illegality are then followed up by calls for enforcement of these new or contested legal standards against the state in question. And the next shoe that would drop would be complaints about double standards against third states or international organizations that refuse to enforce these newly constructed legal demands, partly because they do recognize the real security dilemmas that are posed by complex situations on the ground. So the embrace by law appliers of normative positions that appear to be agnostic to real-world challenges and dilemmas confronting states involved in armed conflicts, especially those confronting rogue actors that bluntly and purposefully sometimes violate international law. And I would posit that it undermines the authority of international law and renders less credible and certainly less popular demands to implement it, even in cases where clear violations have been committed. And again, Israel, like other countries, is not a country that never violates international law. It is engaged, and I would argue that also in the Gaza war, it had engaged in violations of international law, and it should be called upon those violations that include a range of I would say, policies that are unlawful, from destruction, excessive and unjustifiable destruction of buildings and infrastructure, to lack of reasonable precautions vis-a-vis humanitarian convoys, through mistreatment of prisoners, etc. But the upshot of the reality that we find ourselves is that once these more debatable and controversial readings of international law are put forward, and I would say that these positions in many cases would not realistically be compliable, is that both parties to the conflict, the non-state and the state party, would appear to be operating in a large proportionality of their interactions in violations of international law, either because they don't want to comply, and this would typically be the non-state actor, or for the state actor is because it cannot realistically comply with the interpretations of international law that it is required to follow. And the overall picture of compliance with international rules, that this configuration of under-effectiveness of enforcement vis-a-vis the non-state actors and overreach of normative demands vis-a-vis the state actors is rather grim. Now, the third aspect which I want to deal with is the crisis. So we have the rogue states, we have the debatable claims, but we also have hyperbolic use of international law as a form of lawfare, which was mentioned in the introductory remarks by Kirsten. And here we are seeing a host of actors, almost always actors with strong political agendas, that are adopting even more radical interpretations of international law than the previous category of debatable interpretations, but plausible interpretations that I have alluded to. And these political actors engage in highly tendentious law application exercises, often based on us against them mentalities and narratives, and they push forward stronger than necessary legal claims with a view to inflicting reputational harms on the states that they target. And I would maintain that the genocide claims that were put forward by South Africa before the International Court of Justice, and also against the claims made by Nicaragua against Germany, also before the International Court of Justice, illustrate this attitude. The genocide claim has been quickly adopted by many states. Most of them have been hostile to Israel before. I would say that many mainstream international lawyers that have expressed their views on the matter have called for have expressed doubts, at least as to whether the very high threshold the International Court of Justice has established in past cases to prove that genocide has taken place can be reached in the case at hand. Arguing genocide in a case like the war in Gaza effectively replaces other allegations concerning serious, yet less stigmatic violations of international law, which could have been much more easily shown, like war crimes, like maybe crimes against humanity. I will say that even the prosecutor, the ICC prosecutor, at this point in time, didn't charge genocide. His request for arrest warrant is looking at still serious international crimes, but not the most stigmatic and serious international crime, that is genocide. Such beyond arguing more than is actually necessary, I would also suggest that making these specific hyperbolic accusations tend to often ignore inconvenient facts, which do not sit well with the legal narrative embraced by those who are making the claim. For instance, the genocide claim brought by South Africa has tended to ignore the application of precautions that Israel has adopted to reduce civilian harm, including those evacuation orders that I have alluded to before, or ignore the practice of opening more border crossings in order to allow more supplies to move in, or ignore the fact that had the IDF wished to perpetrate genocide in Gaza, it could have applied much more force than the significant amount of force that it actually did. In fact, in the ICJ case, some of the ICJ judges did comment on the tendentious way in which the case has been presented to them. And at the end of the procedural stage, the court did issue provisional measures. It did find that the rights in questions have been plausible, which effectively mean that there could be irreparable harm to the Palestinian group, whether intended or unintended, which is, of course, a very important legal nuance. But some of the judges, most notably the German judge, Judge Nolte, did remark quite explicitly that he found the case not plausible. And did take issue with South Africa not addressing the redeeming factors that render the accusation of genocide less plausible. Now, again, I want to be clear. I'm not suggesting that Israel has been exemplary in the way it has prosecuted the war. Far from it. The harm inflicted on Gaza is massive and it is likely excessive. Certainly the statements made by Israeli politicians have been reckless, and some of them could qualify as incitement to genocide. Yet to maintain that genocide is occurring and not, for example, other serious violations like the ICC prosecutor has done, when the likelihood that the burden of proof for establishing this higher allegations, the likelihood is quite limited, does color the application of international law in these contexts with very strong political colors. Now, the raising of the stakes through making radical claims also makes expectations among broad constituencies for a strong reaction by international courts and enforcement bodies unrealistic. And this is likely to create disappointment when these reactions, once the facts are actually vetted in a legal process, are unlikely to arrive, further harming the image of international law. And we've already seen a small fraction of this in the genocide case that was brought against Russia, where the court was very quick to issue provisional measures against Russia on the basis of a very, I would say, strained interpretation of the Genocide Convention. But the court has not been able, when the next stage of the case was reached, the court had to backtrack from its earlier decision and effectively undo the provisional measures. And it is debatable, more maybe than debatable, whether the court's approach to this case has done more harm than good to the cause that it was trying to protect in this case. Now, when states make wild allegations against other states, this is one thing, because states are political actors. One would have expected international courts to have been acting perhaps more as a restraining factor than they have done. But when this is actually other bodies are going down that path, and I'm thinking now, I'm speaking now about major NGOs and on UN officials, who you would have expected to exercise professional care and prudence before raising allegations of genocide, starvation, apartheid, and the like. Those entities also are at risk of being perceived as entities that are using laws in order to advance a political agenda, undercutting thereby their ability to raise important issues, again, including regarding the Israeli-Palestinian conflict, such as the issues that were raised and discussed and affirmed by the International Court of Justice in its very recent decision on the Israeli occupation of the West Bank, where the court did deal with many important issues and real issues such as discrimination, land expropriation, inhumane treatment due to settler violence, etc. So the concern that I have with regard to this radical application of international law is particularly serious when viewing the involvement of UN officials in such campaigns, what I would regard as lawfare campaigns. So to give you a recent example of a press release that was issued by the UN Special Rapporteur on the occupied Palestinian territory, it runs under the following headline: Apartheid Israel is targeting Gaza and the West Bank simultaneously, says expert. And then the press release cites the rapporteur for the proposition that Israel's genocidal violence risks leaking out of Gaza and into the occupied Palestinian territory as a whole. And 12,000 Palestinians are arbitrarily detained, de facto hostages of the unlawful occupying power. Over and beyond this very loose and hyperbolic use of international law, which obviously seeks to score a political point by minimizing the plight of the Israeli hostages in Gaza, by creating a false symmetry between them and Palestinians held in detention in Israel under legal control, which one could argue whether it's arbitrary or non-arbitrary, but it clearly doesn't meet the definition of hostages under international law. The problem that I see here is the loss of even the appearance of fairness and even-handedness in law application. Now, the special rapporteurs are a group of more than 50 experts who are appointed to deal with specific issues by the Human Rights Council, which is, of course, a political body, but they are expected to implement their mandate professionally and to use it in order to monitor human rights conditions around the world. The council itself introduced a code of conduct in which it set out the normative expectations from the rapporteurs. And I will read a few elements of that code of conduct. The rapporteurs are expected to hold a professional, impartial assessment of facts based on internationally recognized human rights standards, to behave in a way as to maintain and reinforce the trust they enjoy of all stakeholders, to gather information on the basis of even-handedness, to communicate with states in ways that are not politically motivated, to ensure that their personal political opinions are without prejudice to the execution of the mission, and to show restraint, moderation, and discretion so as not to undermine the recognition of the independent nature of their mandate or the environment necessary to properly discharge the said mandate. So in practice, some rapporteurs, and certainly the treaty bodies, have largely adhered to these standards, and they do conduct themselves professionally and seriously, but some have clearly failed to meet these standards without incurring any repercussions. Now, for a fragile system of international law application, the perception that key actors in the system, from special rapporteurs to UNRWA, have failed to meet the principle of neutrality, and you can add to the list, and Kirsten mentioned this, and we can further discuss this in the Q&A, also the rush to request arrest warrants by the ICC prosecutor. All of these decisions do appear to put the law application exercise under increasing pressure and reducing credibility. So how do we get back to more or less functioning international rule-based system? And these would be my closing remarks. There is no magic formula, but still I can offer some initial thoughts and suggestions. First, we need to acknowledge that international law is still a rather fragile system, which enjoys limited compliance and limited buy-in by key actors and political constituencies. It needs to be handled with care and overreaching in terms of making legal claims that have limited support in legal doctrine and state practice, and run directly against the legitimate interests of states around the same legitimate interests, such as peace and security, around which the rule-based order is built. This would not work. It may represent a worthwhile moral gesture to push international law in these directions. It may point in the direction of future developments of the law, but pushing aggressively such positions at this point in time would more likely underscore the weakness of the system, would lead to loss of trust in the system and would make it harder to enforce rules around which we do have international consensus, such as the prohibition against torture or the prohibition of discrimination. And the impermissibility of acquisition of territory by force. Now, this doesn't mean that there is no room for civil society, for academia to push the envelope, to try to challenge the system. This is all very well, and it's actually important. But for entities that have a central place in the system, that are in a way entrusted with steering the ship and maintaining the system, the states are invested in the rule-based system. International courts, international organizations, for them to adopt fringe interpretations of international law is not a good posture to adopt. A related point that I would mention is a recommendation on my part to opt for incrementalism in law interpretation and application to try to avoid hyperbolic legal characterizations where more simple and straightforward ones are readily available. I would commend in this regard the International Court of Justice in its recent advisory opinion on the West Bank, where the court was invited to make a decision on apartheid. And the court refused to make a statement on apartheid. It did invoke a broader article, Article 3 of the Convention on the Elimination of Racial Discrimination, that does talk about racial segregation or apartheid without actually rendering an unnecessary legal statement on a highly controversial issue where the law is anything but stable and generally well accepted. Unfortunately, it didn't do the same with regard to the status of Gaza, where the court did appear to go out of its way to make a highly controversial proposition about the occupation of Gaza prior to October 7. And I will note in the individual opinion of the American judge on the court, Justice Sarah Cleveland, who was critical of the court for going unnecessarily out of its way to make a ruling in this regard. My third and last recommendation is for the UN and for member states to get their act together with regard to the conduct of office holders that violate norms of impartiality, non-politicization and neutrality. These office holders put the entire organization in disrepute and set in place the same dynamics that have led Kofi Annan about 20 years ago to abolish the Human Rights Commission and to establish instead the Human Rights Council. So states that care about international law and international human rights law should prioritize ensuring quality and independence of office holders at the UN and international courts, and to move away from the somewhat lethargic attitude that they have often adopted with regard to such appointments. Key NGOs who used to enjoy much prestige and influence around the world would do well also if they reconsider their drift towards voicing radical legal propositions that often are based on overambitious agendas of pushing for structural change and of collapsing law with politics. So to conclude, the rule-based international order is a critical component of international peace and security, of international law and of international justice. Careless use of international law norms and institutions, and certainly abusive use of them, could undermine what is already a weak legal and political system that is struggling to meet the basic expectations of members of the international community for enforcing international law. At these present difficult times, less is sometimes more and more is sometimes less. Thank you very much.
Thank you so much, Yuval, for that extremely thought-provoking and complex presentation. I hope you all enjoyed it. We have a few minutes for questions and answers. And yeah, I want to see in advance who in the room would like to ask a question, and we'll try and get through it all in time. Maybe we should ask them a few questions at a time. Is that all right with you? All right, let's start here. We'll start here. Yep. And then... Thanks, Dan.
Again, thank you very much for the presentation. I just wanted to ask you about the ICJ ruling about the status of the West Bank, Judea and Samaria. If it was October 6th and if it was up to you, what would you rule? Meaning the claim, the Palestinian claim that Israel has de facto annexed. So October 6th before October 7th, what would be your position on that?
First, I'd like to thank Felice Guerre in absentia because she is a force of nature and she has made all of this possible. Thank you for your very thoughtful presentation. I have two questions. Professor, first, the Secretary General and Volker Turk, his alter ego, have claimed violations of international law with respect to Operation Below the Belt, the pagers issue in Lebanon. How do you feel about that? Do you feel it's a violation? Second, I'm confused about Volker Turk's accusation that when Israel asked civilians in Rafah to relocate, that was forced displacement and therefore a crime. I would have thought it would have been saving people's lives. So how do you stand on that issue? And your point about Kofi Annan was so well taken in terms of the fact that whenever we ask about Francesca Albanese and her tendentious anti-Semitic statements, she even called for Israel to be expelled from the United Nations. The deflections that we get from Stefan Dujarric, the spokesperson, or the Secretary General's office, is that, well, these are independent actors. Well, they're not independent, they're bad actors. And Kofi had the courage, the Secretary General Kofi Annan had the courage to call for disbanding, as you rightly said, the entire human rights apparatus. Why can't the Secretary General Guterres or Volker Turk, it's his apparatus after all, why don't they do something similar?
Let's see. Got one too right here, and then we'll come back around.
Thank you very much for your presentation. My name is Alex Pustonik from the New York AJC board. When we meet throughout the year with diplomats from various countries, they usually come up with a version of the argument that while they understand Israel's right to defend itself, they have taken anti-Israel positions in international fora because they regard Israel's response as disproportional, that it violates the proportionality issue, and they cite the figure of 40,000 plus civilian deaths in their view. My understanding, my very basic understanding, is that proportionality is not really a question of numbers per se, but it's more a question of balancing military objectives with civilian casualties. But I would be very curious to hear your views on how to respond to these kind of accusations.
Thank you very much, Professor. My name is Samantha Nguyen. My question is, do you think that the current international legal system as we know it is strong enough to withstand the lawfare campaigns before the court, specifically when the reports that are cited are from United Nations officials? Thank you.
Hi, I'm Howard Lippman on the AJC Long Island board. This is a simple question, and it makes me think about all the legality. Who actually owns Gaza and who owns the West Bank? Because I'm very confused.
Thank you. I've missed Professor Shany's lectures very much. Always so enlightening. So thank you for bringing him. It's maybe building on the previous question. I have many, but I'll stick to one. But part of what we're seeing is really these soft law instruments, civil society reports by Hamas and others, basically soft law becoming UN resolutions, becoming hard law in sense through the ICJ, through the ICC decisions, and a bit about what your thoughts about that process and if there's anything that we can actually do to combat that.
Well, the most important thing that I should have said to begin with is that I'm sorry that Felice is not here. That Felice has been a close friend for many years, and I'm very grateful for her to inviting me to come last time and also this time. And I'm really sorry that she's not able to be with us, and I wish her speedy recovery. On the different questions. So on the ICJ, how would I have decided the ICJ case on the West Bank, right? You were interested in the West Bank. Yeah, so I would have gone with probably with three judges on the minority, the three minority judges that agreed with the court that there are many violations that Israel has undertaken in connection with the settlement enterprise, which, like I explained before, cannot be reconciled with mainstream understandings of international law. To take the next step and say that as a result, Israel has no business of staying there, I would also on October 6th would say that this is a radical proposition because that really ignores 70 years of conflict. That occupation of territories coincided with attacks against Israel. So the idea that you have legitimate security interests that allows you to control an area for a certain point in time. The fact that you have committed violations means that you have to reverse the violations. It doesn't mean that that's a different question that you need to analyze, whether Israel has security or does not have security reasons to stay. I think October 7th sadly did underscore the point, like the withdrawal from Lebanon, that when you withdraw from an area without having in place good security arrangements, like you had in the Sinai Desert, where you have good security arrangements, and the United States has been an important actor in actually ensuring that those security arrangements are in place. This could work, but when you withdraw without security arrangements, it's extremely dangerous. And I think that those three judges on the court, the French judge, the Slovak judge, and the Romanian judge, I think they understood this point, and I would have joined them if I had been on the court.
The question was the opposite, actually. Because the position of the government, the existing government, is to extend sovereignty. Whether sovereignty is actually being extended, meaning the condition of occupation no longer exists, it's the other way.
Well, sovereignty has been extended de facto. There has been no de jure, okay? As a legal matter, there has been no annexation of the West Bank, with the exception of East Jerusalem, which is, of course, a different matter. And I think that's part of the problem that Israel has in the West Bank, that it is operating within one legal framework, but it is taking actions on the ground that are not really reconcilable with that. So if I was on the court, this is how I would have decided. On the pagers, that's a big issue. I think much of the, I think there is a legal question, a technical legal question as to whether the pagers fall within a specific treaty, the second protocol to the Convention on Conventional Weapons that are there to outlaw booby traps. I think it could be argued both ways, that pagers are seemingly harmless objects. It could be also argued, on the other hand, that pagers that are used for military communication are not seemingly harmless objects. So I think it's fair to say, I think the broader arguments that were made about indiscriminate and disproportionate attack, that I think the facts that so far have emerged do not support these propositions. So I would be much more careful than Volker Turk has been on identifying international crimes here. I think that's a bit outlandish on the basis of the information we currently have. On the eviction, I did speak generally about evacuations in Gaza. That would also apply to the Rafah evacuations. My position is that these evacuations are generally within, if not the letter, certainly the spirit of the Geneva Conventions. Of course, you have to take measures to ensure that people who are being evacuated are not evacuated to another, from one place of active fighting to another place of active fighting. But the whole idea that you cannot evacuate civilians from active theaters of hostilities, I find it extremely difficult to reconcile with my understanding of international law and the world of that we live in. And with Albanese and more generally the rapporteurs, I think there is a point about the independence of the rapporteurs. And of course, I should say there is also pushback in the other directions. I mean, there are countries like Russia that are very happy to cite the code of conduct against the rapporteurs and try to curb their independence. So we need to be careful not to throw the baby with the bathtub waters. I mean, the rapporteurs are important, but I am concerned about the selection process, that people who are being appointed are appointed, notwithstanding the fact that everyone knew who Francesca Albanese is and what are her opinions. She didn't make it any secret. She was appointed exactly because of those opinions, as had been her predecessors, most of her predecessors in that position. So that is, I think, a very bad set of practices that the UN has engaged in. And secondly, there are ways for the organization to dissociate itself from certain outrageous conduct by office holders. And independence is important, but it's not the only value that we have within the system. So I don't think the Secretary General can fire Albanese, but he can certainly distance himself in a more clear way from some of the more outrageous statements. On the issue of disproportionality, so yes, you're absolutely right. Under IHL, international humanitarian law, the test is really not overall how many people were killed in a conflict and how many of them were soldiers, how many were civilians, but rather each specific attack, whether the collateral damage, so to speak, is excessive or not excessive in relation to the military advantage. And that's how you apply international law. Now, there are some theories, but I would argue they are not mainstream theories, that with the very right to go to war or to apply military force under what is called jus ad bellum, the law governing the very opening and maintenance of a state of war, there is a principle of proportionality. This has never been applied up until now by any court, and there is great disagreement among international lawyers. So this would certainly fall within my mid-range category of debatable interpretations of international law. You could make a moral claim, and I would say this is probably, or a political claim, that too many people have lost their lives in Gaza, and I will agree with that proposition. Too many civilians lost their lives, and this is extremely bad. Some of it lay on Israel's shoulders, much of it lays on Hamas' shoulders. And we should find a way to end this war and end this suffering. But I think making a legal claim to arrive there when the law doesn't clearly support this proposition is highly problematic and falls into the dynamic that I was describing. Is lawfare, you asked me about lawfare and will it withstand? So I expect there will be decisions. I expect the ICC will issue its, I would be surprised if the ICC would not issue arrest warrants. I should say the ICC has always issued arrest warrants. Okay, there has been only one case where they did not issue, but after a second round of the prosecutor was sent to do some homework, and the second time they did issue. So the likelihood that this is the first time in the history of the court that they will not issue is not very high, although we will see. Maybe some of the charges wouldn't be confirmed, but this is something we will see. And the International Court of Justice might issue some very difficult decisions. It already issued some difficult provisional measures decisions on Israel. But in what way does it mean that it would withstand? You have on the law books, you have decisions like the decision on the wall, which the International Court of Justice issued, the advisory opinion, it was not implemented. I wouldn't say that it had no impact. It did impact the way the Israeli Supreme Court approached these issues, but it was not fully implemented. So you continue to have this distance between law as it is pronounced by international bodies and law as it is applied on the ground, and that will feed into greater disappointment by actors from both sides So the Israelis would be upset about bias, the Palestinians would be upset about lack of enforceability and double standards. And the end is that we will continue our battle, right? But one of the collateral damages is going to be the international law system. So I think it's ultimately, if I have to reduce my speech into one-liner, is don't bite more than you can chew. On the question of who owns the Gaza and the West Banks, so sovereignty on the West Bank and Gaza is extremely a complicated question. On Gaza, I would say it's a bit easier because Israel hasn't put forward sovereignty claims with regard to Gaza and was quite happy to withdraw from Gaza. And even in the Camp David Accords, it actually asked Egypt to take Gaza from its hands. So Gaza is more clearly an area in which the Palestinians can exercise their right to self-determination, which all of the world, including Israel, recognize. They do have a right to self-determination. They are a people, and they do deserve a political framework, eventually a state. West Bank has this very almost impossible complexities of going back. I think there would be at this point in time strong support I think it would be a reasonable application of international law to maintain that the West Bank is an area in which the Palestinian right to self-determination has to be implemented, and the exact boundaries between Israel and the Palestinian entity state would have to be negotiated by the two parties. Israel does have some sovereignty claims, but it has not been very effective in pushing them forward. It didn't even bother going to the International Court of Justice and making its sovereignty claims. So when you repeatedly don't make your claims in the fora, which at the time in which it counts, and when decisions are issued, your case is becoming weaker and weaker. And finally, Ifat, on soft law, yes, I mean, this has always been the case in international law, I would say, at least from the 1970s, when the balance of power in the UN has changed, and suddenly you had the developing countries have a majority in the General Assembly, and they could pass whatever resolution they could pass. And then there was a process, and there is an ongoing debate as to what are these resolutions, what is the normative value. I think for many years, the West has been quite resistant to accepting that this is part of international law, but I think that this resistance is weakening. And I think that there is, in a way, you're right, that we are seeing perhaps a growing dynamic of soft law becoming effectively the norms that everyone cites, and also maturing into hard law. So this is a process. You could say that there are some, because treaty making has become so difficult, which also has to do with my comment on populism and, for instance, the inability of the US Senate to pass any treaty. So all you have at this point in time is probably soft law. So I wouldn't completely see this as a negative development for global stability.
Very impressive. Thank you for taking all of those questions. Ladies and gentlemen, I want to thank Yuval Shany for a wonderful exploration of very complicated issues, and for so generously taking all the hard questions. We're happy to have you. We're happy to have the lecture series revived, and we look forward to seeing you at the next JBI lecture. Thank you.
No, that's okay.